And we're live with Christopher Berry, attorney from the Animal Defense Fund. Well, give me the correct title there, Chris, of your organization that you represent.
Yeah, I'm a staff attorney at the Animal Legal Defense Fund. You can go to aldf.org and follow us on social media, Twitter, Facebook, and so forth.
Okay. And you're based in California, and now at this moment actually in Miami, and earlier today in a small town of LaBelle, Florida, in Southwest Florida. So Chris has been moving around. And tell us what you were doing in LaBelle today and yesterday, Chris.
Well, we were in LaBelle representing 3 landowners in Hendry County, which is a rural county in Central Florida, for people who aren't familiar. And we were suing Hendry County for getting well, not one, but ultimately 3 primate breeding facilities in the county under agriculture. And the reason that that's problematic is because agriculture, but sort of by its ordinary meaning and by definitions you would see in the dictionary, really is related to the production of domestic animals, not wild animals, for things like food and fiber, and not breeding monkeys for biomedical research. So the county, we argued and we believe, was required to provide public notice and to determine this important zoning policy issue at a public meeting with opportunity for some public input. But that never happened. So we are suing them under Florida's Sunshine Law, which requires that all policymaking be performed at a public meeting after reasonable notice.
Yeah, and as an observer for the last couple of years on this, it certainly seemed fair to property owners that they should be notified if something unusual is going to be taking place next door to them or close to them. In this case, the possibility of literally thousands of monkeys to be raised for biological research. And that was the problem. Now, the county, on the other hand, again, as an outsider, it appeared to me they were taking some big shortcuts to allow this to happen. It seemed to me primarily because we have a economic development council who wants to bring money and jobs and businesses into the county. So they seem to have rounded up these folks to start these monkey breeding facilities, and we're eager to have them come into the county. And the county says, well, we'll do what we can to help you, and let's see if we can maybe adjust the rules a little bit to allow it. So now the county's defense, which again, to somebody who's not familiar with the legality, seems utterly appropriate, that they claim this is a farm, it's on agricultural land, and you know, you can raise horses and cows and pigs, so why can't you raise monkeys? And then, so their defense is saying, well, even though you're supposed to have open access to what's going on under the Sunshine Law, this one didn't require it because our code already allows for breeding of animals. So what was your argument against that, Chris?
Well, the ordinance doesn't allow, quote, breeding of any number of any animals. Specifically, it's limited. It defines agriculture as animal husbandry. And animal husbandry, we just pulled out a dictionary and it said, breeding and raising livestock or domestic animals. Sometimes it'll say livestock also domesticated animals. It's clear, it's clear just by doing a little bit of research, really the bare minimum amount of research that this is limited to domestic animals. And in fact, the majority of Florida counties have exotic animal ordinances. The county put on an expert, for example, who had worked in 2 other counties, besides Henry County, and was familiar with their land development codes as well. And she admitted at the trial that those two counties had special exotic animal ordinances, and that's typically what we'll see. Trying to fit a square, try to fit a round peg into a square hole is precisely what the county seemed to be doing here with this idea that a biomedical primate breeding facility would qualify under agriculture. And you can, without limiting it to domestic animals, which really is the plain meaning of agriculture and animal husbandry, without limiting it that way, there are even similarly or maybe even more absurd examples of facilities that could be permitted there without any sort of notice to the public or to the nearby landowners. So, for example, 1,000 rhinoceroses. You could breed 1,000 rhinoceroses, or 1,000 elephants, or in theory, if you had the space for it or the facility designed for it, 100,000 elephants or 100,000 rhinoceros. And according to the county, all of that would be completely compliant with their agriculture zoning code, and they wouldn't provide any notice for that to the landowners. And certainly there wouldn't be any notice of it in the land development code, because anyone who looks it up will see agriculture and you'll think cows, chickens, sheep, horses, and the like.
Now, one of the other defenses the county was trying to give to the judge was that under the code as they see it, there was no requirement to notify any property owners in the area, or anybody for that matter in the public, that there was going to be a monkey breeding facility, claiming that agricultural uses is just a pretty standard thing. So there's no requirement under the Sunshine laws to do so. And what was your argument against that?
Right. Well, they've contended that they didn't have to provide any sort of notice or public hearing, and they really had sort of two arguments there. One is that under the normal county permitting process, there was, you just don't have to provide public notice when you're approving what they call a site development plan, or other counties call it a development order. So in sort of the normal course of business, that's just not required by the county code. Unfortunately, the local laws are superseded by state and federal laws. And in this case, the state of Florida has a law. It's called the Sunshine Law. You could look it up if you want. Florida statute section 286.011. And the Sunshine Law requires that any official act be performed at a public meeting after reasonable public notice. And the Florida Supreme Court has said that an official act that requires this public meeting and notice is anything that amounts to a, quote, policy-based decision-making function. So really the key inquiry is whether the county staff engaged in policymaking. And even the county referred to this non-human primate breeding allowance as a county policy. They refer to it as a policy that they've had since they started permitting these facilities in the early 2000s. So it's clear what they did was they created zoning policy that, even if they didn't amend the zoning code, it certainly looks and functions exactly as a amendment to the zoning ordinance would be. And that's clearly the type of function that's required to be performed under the Sunshine Law at a public meeting with reasonable public notice. So that's really the heart of our argument here, and sort of the heart of the controversy as the judges identified it.
Yeah, I started writing stories about this a couple of years ago, and one of the most oddest things that I found, which may not be odd in the overall scheme of these monkey breeding facilities, was that I tried to track down who the owner was, and it started out with a limited liability corporation registered in Florida, and the managing partner was another limited liability corporation, and their managing partner was another liability corporation, and then it eventually ended with a corporation that was not registered in Florida. So I was wondering if there was any legal technicality about having a company operating this facility and applying for the permits and so forth that wasn't ultimately registered in Florida. Was that any factor at all, Chris?
That didn't play into the trial at all, but I went down the same rabbit hole that you went down when I was researching this case as well. And the property owner is SoFlo Ag LLC, and they're as you said, their managing member. This would be normally where you would list the CEO or a president. If you look up even the other primate facilities in Henry County, they all have real people listed as their executive officers. But SoFlo Ag, for some reason, listed a shell corporation there called P2B2, and if you look up P2B2, you can Google this Florida business entity search. P2B2 also listed as its managing member another shell corporation, and that shell corporation, they didn't even bother to create a shell corporation there. Additionally, SoFlo Ag and P2B2 their headquarters is a UPS box, if I recall, at least last time I checked. And it wasn't technically relevant to the Sunshine Law violation issue, but certainly those citizens of Henry County, I think, would be very interested to inquire about that, why these shell corporations are being used, and why natural persons, there's no natural persons being listed as having executive responsibility over these facilities. And that's really problematic because non-human primates are capable of carrying, for example, zoonotic diseases that can literally kill people. And in fact, some of those diseases have been listed as like federal bioterrorism possibilities. I think herpes B was on the list as a possible federal bioterrorism agent for a while. These are deadly diseases that can be carried. There's an environmental contamination that could occur. The monkeys themselves could escape, and they could ruin the pristine Florida natural parks that are down here in the state. So I think it's really important that there be some responsibility, and having a public hearing would give an opportunity for the citizens to say, well, maybe the code doesn't require a natural person being listed as the owner of a corporation, but we would really like to know who this is and what are they trying to hide by concealing their identities.
Yeah, and in some of the papers that you filed, you mentioned one of our local engineers, Rock, and his partner, I believe, was David. It wasn't clear to me whether they were the original owners of the land that was sold to the SoFlo. How did that play out there?
Yeah, well, Rock, they were the developers. So, really, we know almost nothing about SoFlo Ag, about its structure. We don't know who the owners are, why they're trying to keep secret. What SoFlo Ag operated through agents. They had an attorney. They also had this Rock Engineering. It's a developing consulting firm, from what I can tell, and they operated exclusively through them. What's even more interesting, and because you can see this in public records, and we got this in discovery, is that that they wouldn't even deal with the county when they were trying to get this development through. All their communications, from what we can tell, were being routed through Greg Gilman of the Economic Development Council in Henry County. Even the SoFloAg, the people who were sort of representing SoFloAg, they wouldn't even deal directly with the county. They would only deal through an intermediary at the Economic Development Council. I just, for the life of me, I can't understand why you would go through that much secrecy. It's certainly not customary in the primate breeding facility business to go to that great of an extent to conceal your identity and to distance yourself from the government decision makers, or from the public for that matter. And again, especially considering the nature of these facilities, and you have to quarantine the animals. They can carry and transmit deadly zoonotic diseases. I just don't know why all the secrecy.
Well, I asked Rock about that some years back, and of course his response was that because of the controversy about breeding animals for lab experiments, that sometimes the owners don't want to be harassed, and so they want to be kept quiet. So I was wondering, and you may not know the answer either, but if Rock was somehow involved in the company. I'm just conjecturing. I have no idea, because what piqued my interest was when you said he was the developer. And when I think of developer, I think that he owned the property or he developed the property. I know he did the engineering plans for the site plans, as I recall. Mm-hmm. Did you determine whether he had some ownership in the project or anything?
No, I have no idea who the owner is.
Yeah,
they've been Prelabs LLC, which is a Chicago company. It's been reported in the media that they have something to do with this, and there has been some form of affiliation between SoFloAg and Prelabs, this Chicago primate dealing company. But
yeah,
I don't know beyond that what the extent is of the ownership or chain of responsibility beyond that sort of affiliation.
Did you attempt, or maybe there wasn't any legal reason to subpoena the owners? There was a Mohammed something or other that was a representative of Prelabs or something, as I recall, who I thought might have had some ownership to that. Did you try to subpoena or try to get somebody from the company to, ask them how they came about doing their application and all that, and how they, met with the county and so forth?
No, we didn't attempt to do that. We stayed focused in the lawsuit. We stayed focused on the sort of the secret zoning policy that was happening that cut the public out. And so that really was the focus of our litigation. It'd be nice to sue people over everything that you find objectionable. So sometimes it's not always possible, or prudent to do that. And, that's just the way the law is.
Right. And of course, not a part of this lawsuit, but could you explain what the probable use of these macaque monkeys would be if they had permission to put them in the new SoFlo facility?
Yeah, they'll breed them. I've seen news reports anywhere from, somewhere about 3,000 to 5,000 monkeys that they'll be able to fit in the facility. And they'll breed them. They'll sell the baby monkeys to to animal research facilities, which is problematic on its own. Animal welfare, of course, isn't related at all to the sunshine. Certainly, welfare concerns regarding the use of these animals in research. Macaques, for example, are very intelligent animals and have been known to pass the mirror test, which means that they can recognize themselves in a mirror, which is a feat that very few animals are capable of. And in addition to that, a lot of the research on macaques is really I don't even think you could argue that it's necessary or that it's for life saving. We've seen the creatures used for maternal deprivation studies. Animal Legal Defense Fund was involved in trying to obtain public records from the university to their approval of maternal deprivation studies. And if you're not familiar with those, that's where you take a baby monkey and remove the monkey from his or her mother, and essentially you do sad things to the monkey, or you take them away from the mom, and just to see how they react to it, which is something that we've known for a long time will cause all sorts of psychological issues.
Yeah, I think I understand that the federal government or some agency has outlawed the use of chimpanzees for experimental work like that. Mm-hmm. And I'm wondering why not these particular monkeys as well?
Well, chimpanzees are our closest relatives. They, on cognitive tests, great apes perform better than even macaques do. So it's, the controversy has really been focused on the use of chimpanzees in research. And I imagine you'll see going forward a push to expand that sort of circle to include more non-human primates, but that's just not what's happened so far.
And I've heard that our rural county here, Hendry County in Southwest Florida, is so-called the monkey capital of the United States. I'm not sure how true that is. From your experience, do we have a whole lot of monkeys more than other states for use in experiments, or are there other states that have this similar type of situation?
I've haven't done a full state survey. I've seen primary breeding in Missouri, I think Texas and Louisiana as well. I wouldn't be surprised to see them sort of all, throughout the South. It's what they call below the frost line, where it never freezes, sort of the ideal climate to produce them. But Hendry County is the only place one of these facilities, and I'm not sure. There might be other locations with more, but as far as I know, Hendry County does have the most.
Yeah, it was just odd because it has been a real secret here. I mean, I've been here for 15 years and doing news for most of that time, and I didn't know that we had thousands of monkeys in cages here until this SoFlo thing came along a couple of years ago. It was really a well-hidden secret. Did the Animal Legal Defense Fund, did they fund the entire legal bill for this, or were there other entities helping the 3 residents that brought the suit?
We represented the clients pro bono, so we paid the costs and represented them pro bono. When we take a case, we don't require people to pay us.
And then your co-counsel, was she doing it also pro bono, or was she working with your group?
Yeah, she's not. So Justine, she has her own firm, and she's worked with us on other cases, and she worked with us on this one as well. Since we're located in California, but we're from everywhere. Personally, I'm from the Midwest, but we're headquartered in California, and we do cases everywhere. So we tap into our network of attorneys to, you always want to have a local connection to things before you proceed. And so she is based. She's based here in Florida, and was gracious enough to help with the project as well.
Yeah, and you had kind of an interesting situation yourself, because of course you're a California bar attorney, and to practice in Florida, you have to be a Florida bar attorney. So you had to get permission from the court to practice, was that any difficulty, or is it kind of a routine thing, or how did that work out?
Yeah, it was a routine. It was routine. The court graciously granted it without, without any sort of issue.
I was just wondering if the county objector, is there any valid objections if they wanted to object to that?
I don't know. I mean, I've never seen an objection, and I think,
It seemed
you don't want to litigate over things that are pretty inconsequential like that. So, you
yeah,
have some objection to raise. You normally
right.
out of professional courtesy and not wanting to waste your time or waste your client's money if you're being paid by a client. These things work out.
Now, the county attorney who was co-counsel, his apparently the county hired a very experienced government lawyer, government specializing in government affairs, for the co-counsel. Is that kind of typical where smaller counties will hire some really big gun from out of the area to represent?
Well, certainly preparing for trial is very difficult. So I don't know why after the county attorney had represented them through most of the proceedings, they added the second attorney. I would guess it was probably just to help manage the trial, which really takes a lot of effort to prepare. You have to prepare exhibits. There's motions in limine, right? These are sort of pre-trial evidentiary motions, and there's a lot of work that goes into it. So I would guess that was it. There could be other reasons. I suppose someone could do a public records request, probably find out what that reason was, perhaps. Could also be protected by attorney-client privilege, but it certainly seemed like a normal, probably prudent thing to do.
Was there any talk of settlement or compromise through the last couple of years on this?
Yeah. Well, let me think here. Any sort of settlement talks didn't really go anywhere. There was just irreconcilable positions.
Yeah, because in court yesterday, I noticed, and your co-counsel noted that attorneys are noted for producing paper, and there certainly was a lot of paper with voluminous notebooks that seem to have several hundred pages at least in them. I am guessing that the county probably spent way more than $100,000 on this case just because of the volume of papers that would have to be reviewed. And then on the other hand, your work for your three clients pro bono is a kind of a miraculous thing to have attorneys represent some citizens in a small county in a case that went on and on and on, and thousands of documents. I can't even conceive how attorneys can say yes to that. I mean, it's just such a huge job.
Right. Well, I see a lot of value in it. Certainly we saw value in it here at the Animal Legal Defense Fund. And, you might wish that there were laws for animals that perhaps better protected them in some ways. But one, I think, really important dimension to just public interest advocacy generally, whether it's animals or civil rights or whatever, is simply transparency. And that's an important value in itself. And it seems clear to me that the county essentially created a policy that, hurt not only animals, I think, more importantly in this case, really hurt the community and the citizens of the community. And they didn't have any input about, whether they wanted to add an exotic animal ordinance or a primate breeding ordinance to their county code, as other counties have done. The county just decided to sort of cram this into agriculture, when in this ordinary and plain sense of the term, this wasn't agriculture, it wasn't animal husbandry. And just elevating this and shedding light on it hopefully forcing the county to revisit its policy and to either amend its code, or conduct special hearings for a variance or a special exception for these types of facilities going forward. There's a lot of value in that. So, we're definitely happy to take the case on and to fight for that.
Chris, one thing I noticed over the last several years is the response from the community. Now, I was guessing that people would certainly feel responsible for how we treat animals and how we use them for experiments. But it turned out our county was not too worried about that. And I guessed that it might be because, in fact, we are a rural county where people are used to raising horses and cows and pigs and chickens and slaughtering them for food or clothing and so forth. So it's kind of second nature that animals are to serve our human purposes, and therefore using monkeys for experiments, even though they might be horrendous experiments, didn't faze them, and it didn't seem to faze them. Now, you did have a group of folks who were very supportive, and they actually showed up to the trial, a couple dozen folks, and they picketed and went en masse to meetings and so forth. But have you found that phenomena in different areas of the country where rural folks don't seem to really care, and maybe city folks care a little more?
I mean, there's if you're asking whether there's cultural differences between urban and rural areas, I think that certainly is the case. But I found rural people care about animals just as people from the city do. And I've also found, that both urban and rural people care about, open government and transparency. So I think there's a lot of, as this case demonstrates, perhaps, but, there's shared values, across all these different axes.
Yeah, exactly. I mean, it just seemed to me there was a cultural difference going on, and I spent most of my life in Miami, and I'm almost expecting that if this kind of a trial went on there, we'd have a whole lot better support for the citizens living near these facilities, and just in general a lot more support. So I was kind of shocked and almost embarrassed that there weren't many people that seemed to care. In fact, on my blog on this story yesterday, one of the commenters, basically was saying, well, get over it. They're animals, basically, So, I'm just kind of embarrassed that we have to have that attitude.
Well, I wouldn't read too much into, what someone online says. There's trolls everywhere. But in my experience, in Hendry County, everyone's been very nice and very supportive and very outraged by this. Certainly, in the media, the local media coverage, and that I've seen from some of the newspapers out there, and the comments there, and just sort of back and forth with other people that we've encountered there. I think that this is an issue that really resonates, and I think people really are upset about the lengths that their government went to keep this all secret. So that's been my perception on the ground, certainly.
Yeah, and I don't know how many folks were cognizant of the fact that we had a celebrity here, kind of cheerleading, and she's been here, Miss Velez-Mitchell, has been here many times with the group. So she was giving her support at the trial and doing some interviews. So that's good to see her doing that, because again, presumably if she were a lawyer, this would be pro bono. I mean, she's spending some money out of her pocket to travel from New York or wherever to Little LaBelle and spend a couple days attending trials. So hats off to Jane for doing that as well. And of course you folks out in California deserve some big applause, if not some money sent to you for helping out the cause. Okay, well, I think you've done a great job in presenting your case to the court and helping our citizens and helping to perhaps straighten out our county government to make it a little more transparent, or quite a bit more transparent, and to stay with the way the Florida legislature intended things to go, but that remains to be seen. And from what I understand, the judge is going to ask both sides to present a proposed order, and then he'll look that over and make a decision probably in a month or so. Is that your understanding, Chris?
Yeah, I think that sounds about right. We'll file our some post-trial filings within the next week or so, and then expect a ruling, one or 2 weeks after that, maybe a little bit longer, depending on how long the judge requires to, have a good, solid analysis there.
Right. I missed most of the trial, but I was curious who the county produced as witnesses, other than the planning director. Oh, and I was a little confused about that. She had a different title for the court. During the court, she was a witness, and she was a something, which I didn't quite understand.
Party representative?
Yeah. What is that?
Well, parties are entitled to watch the entire trial, and to sit at the table with you. We would have had our client sitting with us if there hadn't been 3 of them. But the county, since it's a organizational entity, was able to designate a representative who was entitled to sit at the table and sort of make decisions on behalf of the client. And so they elected for the planning and zoning director, who was also their expert witness, to do that. One of the practical effects is that she can't be sequestered from the other witnesses, but they're entitled to do that. So.
Right. Okay. And what other witnesses did they bring?
The former associate planning, zoning and planning associate,
right,
Sarah Catala, who she was the one who used, at least for the planning and zoning side of all of this, was at the helm when the 2 monkey facilities in question applied for and received their permits. She no longer works for the county. In fact, I think she's running for county commissioner herself now.
Correct. Mm-hmm.
As reported in a recent news story. So.
All right. Did they produce the county manager, or did you produce them?
We subpoenaed the county administrator, Charles Chapman, to talk about his dealings with the board and the board of county commissioners' involvement in all of this. As I said earlier, the Sunshine Law technically says an official act of a board or commission. So normally this would be like adopting a zoning ordinance by the Board of County Commissioners would be sort of a quintessential official act that would be subject to the Sunshine Law.
Uh-huh.
We're saying that rezoning happened at the staff level, and I think under Florida law, certainly the Florida Supreme Court has said this, that such an action is subject to the Sunshine Law, even if there is no board or commission, because they're basically putting on the hat of a board or commission there. However, what was interesting in this case is that the board, was knowledgeable and interested in this non-human primate breeding policy, and it had come up at several board meetings. It was never on the agenda, so there was no public notice that this was being discussed. And it was discussed, and the board itself didn't actually take any action. But what they did, I think, was acted through inaction. That they had knowledge and involvement with this policy, throughout its lifespan, and they acquiesced. They acquiesced to their staff. Essentially, they were handed the ball, the option to do something about it, and they gave it back to the staff, and allowed them to continue on with this policy of wild exotic animals as agriculture. And so that, I think that was another interesting aspect to the case. the county administrator was able to speak to that a little bit, since he's really the at least since 2013 has been the conduit between the county commission and the staff. But there were indications of the Board of County Commissioners being, interested and involved and acquiescing to this policy as far back as I think 2000 or 2001.
Are there any criminal penalties involved with the Sunshine Act?
I would have to double check. My recollection is that there are criminal penalties for intentional violations of the Sunshine Law. I think there might be a misdemeanor penalty for that. But certainly, we weren't alleging, nor did we need to prove an intentional evasion. I think what the facts certainly support in our case was, I think, negligent planning and zoning work, where all you had to do was pull a dictionary off the shelf, look up animal husbandry, and you would see that, this applies to domestic animals. Even I could list off the number of authorities but really the crux of it is that animal husbandry and agriculture, that this is all limited to domestic animals for food and fiber, right?
Right.
Not monkeys for science.
Yeah. That was, years ago when I started writing about this, that was the first thing that hit my mind. Just looking up the, like you say, the dictionary definition of animal husbandry and the domestic animal stuff. It's food and fiber and that kind of stuff. And so I thought, how could they do this? Now, could they retroactively, the county commission, write a new ordinance that would be retroactive and make this whole thing legal?
I would, have to sort of look at the precise process that they go to and check the law to, see if it appeared to violate any law. My sense is that really at the end of the day, the remedy that we're asking for is just to have all this be considered at a public meeting with public input. And this is a sort of policy decision that needs to be made at a public meeting with public input and of course some reasonable public notice. And once that's done, as I've indicated, other counties do have policies for exotic animals. I think the common denominator is that if you want to build an exotic animal facility, you have to get a special exception or like a variance, and have that be held at a public hearing incidentally. So I think that's certainly what most Florida counties do, from what I've seen, and it certainly seems like a sensible approach, unless short of a total moratorium or prohibition on it. So I think that's sort of the range of reasonable options that you could have. What Henry County is doing now was, I think, quite extreme, and the examples that we gave of 1,000 rhinoceroses, or frankly 5,000 potentially dangerous monkeys being permitted in your neighborhood without any notice to any of the landowners and no notice to the public. That's really on a far end of the extreme. It crosses the line, frankly, and so that's why we're in court.
Was this a fairly unique circumstance, or have you found this happening in other parts of the country where they kind of secretly or bend the rules to allow these facilities?
It's not, to be honest, that's not something I've seen. I have looked at permitting and sort of land use issues with a handful of other facilities, slaughterhouses and so forth. Hog breeding farms and things of that nature, and they all go through a much more open and transparent process, even for those types of things. And you'll see stories sometimes where enough neighbors mobilize and they say that this isn't good for our community, even if it's going to bring jobs, that the harm outweighs the good, and a political decision will be made not to allow the facility. And then you'll see it go the other way as well, where the decision is made to allow it. But what I see common to all the places except for Hendry County is that there is some transparency in these types of process.
Right. Yeah.
And the examples I gave, slaughterhouses and farms, I mean, those are more transparent, and those would, I think, more clearly fall under the definition of agriculture or a confined feeding operation. They would fall under those definitions of agriculture. And even then, I see more transparency in other, thinking of a factory confined feeding operation in the Midwest. So I guess that's what we're working with, and shed some light on it.
Right. Well, I want to thank you very much for taking some time out this afternoon, Chris, because you've been an extremely busy person for sure for a long time, not only this week, helping out the folks in Hendry County. And how might people contact you or the fund if they should get more information or even to make a little donation somehow?
Well, if you want more information about what we're up to, you can go to aldf.org. We have a Facebook page, Animal Legal Defense Fund, where we post a few times a day. We also have an Instagram. I think we have a Pinterest, and we have a Twitter account as well. So, I'd encourage you just to follow us on there, and it's a good way to stay up to date with developments. We have a full docket of litigation. This is just one of many cases that we work on. So definitely encourage people to watch it. It's really interesting work for me to do, so it should be interesting for other people to read about.
Yeah, very good. Well, once again, thank you very much. We've been talking with Christopher Berry of the Animal Defense Legal Fund in California, and very enlightening to hear the ins and outs of defending the rights of citizens and open government and defending indirectly the rights of animals, although that wasn't a part of the lawsuit at this point. So thanks again, Chris, and we wish you good luck and a good trip back to California as you wait there in Miami.
Thanks a lot. Good chatting.